Hello, everybody. It's Mark Pruitt for another strategic money tip. We appreciate you being here today. We're joined today with an attorney, Mr. Lorne Book. Appreciate you being here today.
Thanks, Mark.
This is actually part 2. If you did not see part 1, I would encourage you to do that, because that part 1 is dealing with the death side in the dying or the passing. Once you would pass away, having what are the options in regards to your legal documents on that side. So whether it be you did nothing, whether you choose to look at a will, whether you look at a trust. And it's interesting, Lorne, you said that there are no absolutes. Every family has a different answer for those answers there as far as which one that they're going to pick. And so not everybody, we would never tell you that not everybody should always do this or do that. There are options,
Sure.
And they should always consider.
When we do seminars, when we do educational seminars, I make the quip that, every family is a snowflake, all unique, right? But at the end of the day, we're all made of snow.
Right.
And so
exactly.
there is information that's general to the public that they can consume in ways that help them become better educated, so that when they do sit down with a professional, maybe they're not hearing things for the first time, which they may forget. Or 2, they can come with some well-educated questions that, rather than starting from scratch, we can start to build on and make that time a little bit more productive.
And it's really the same thing today on the same topic that we're going to talk about. Is not the passing side once you've passed, but we're going to talk today about the living side. If you're still living, but you cannot make a mental decision on your own behalf, and you cannot speak on your own behalf, then who have you given permission to be able to speak and act on your behalf? What is, speaking, such as speaking to Medicare, speaking to a company that has required minimum distributions and where only your name are on the accounts, speaking to a financial institution, signing tax forms as you're filing taxes. Can they do all of these things? So what permission have you given someone? And you don't get to do that just because you're married to a spouse in many cases. I mean, think about it like this. Have you ever been on the phone and they go, "I'm sorry, sir, we can't talk to you. You're not on the account. We need to get permission from your spouse." And so you hand the phone over and they go, "Yes, they have permission for this," and then you hand the phone back. Well, what if you can't do that? And so there are documents that need to be in play, and that's why I wanted Lorne to talk to you about this. And let's talk about the first one, which is the power of attorney for finance, or maybe another name, and I'm given the generic name, is maybe a durable power of attorney for document, and kind of tell people that's a living document and what that document is designed to do.
Absolutely. So the durable power of attorney, the easiest way to explain it, usually for clients, is that if you start from the premise that I can make my own decisions, but I also am aware that I live in the real world where I might get hit by a bus, I could have a stroke, I could have a health event, I could be out of town. And legally, in order to transfer decision-making authority, in other words, to give somebody the ability to bind me and my accounts to transactions or whatever, I need a legal instrument that's going to allow me to do that. Right? That's what the durable power of attorney is all about. Informally, we might call it the financial power of attorney.
Okay.
That is a document where you designate an individual, or what I usually call a batting order, if you will, a succession of individuals who can make those financial decisions on your behalf, can think for you, can decide for you, can sign your name for you as your designated legal representative, and on the strength of that signature and the power of attorney, withdraw money from your account.
And you mentioned something, a batting order. I call it a pecking order. It's the same thing, to where you're not just picking your spouse, such as the "honey, I love you" clause. That's what I always call it, to where they're going to act on your behalf. But I always try to encourage people to go 2 or 3 deep if they can, in regards to don't just pick your spouse, but also pick what happens if something happens to your spouse. Who would you want next? What happens if the next person can't do it? So the deeper you can go, and we're not telling you if you got 20 people back there to line them all up, but we're saying go 2 or 3 people deep. Is that what you normally recommend?
I like to see at least one backup across the board, particularly for husbands and wives, because if you just consider statistics
Right.
Who travels in a car more often
Right.
together? Husbands
Right.
and wives. So if you're going to have a mutual injury to an agent, it's going to be a spouse if you've named them as the first person
So
to
minimums
serve.
have at least one other backup besides your spouse. Maybe two would be better, or at least gives you a little more depth if need be.
I like to see a good backup plan.
Yeah,
And so
yeah.
at least one person, yes.
Okay, so durable power of attorney for finance, that's one of the living documents that we say that you should have in your arsenal of documents for estate planning. Another one, tell them about the directive to physician. I call it sometimes power of attorney for medical, but I think the what you print is directive to physicians. Tell people, what does that do?
Sure. So there are actually two what we would call medical directives under the Texas Health and Safety Code. One would be what we would informally refer to as the medical power of attorney, and the other would be the advanced directive to physicians, what I often call the life support directive informally. So can I touch on both of those?
Absolutely.
So the medical power of attorney is a legal instrument where you name someone to communicate with your healthcare providers, doctors, nurses, surgeons, whatever, if you, for any reason, cannot communicate with your doctor. And it is important always to remind clients, as long as you can communicate with your doctors, even if all you can do is blink your eyes or write with your teeth,
You don't need that document.
well, I wouldn't say you don't need it, but
Well,
you
and
have the
then-
right to make those treatment
Right.
decisions. Yes.
You're in charge of yourself until you can't, and when you can't, those documents speak for you.
That's exactly right. And the medical power of attorney is designed to give general medical decision making over to someone that you trust to make decisions based on your known wishes. Maybe you're okay with acupuncture, but you're not okay with, the witch doctor coming in or
Right.
something like that, right? They know your religious preferences. They know your health preferences. They know what you're allergic to most of the time, right? That's the person that can step in and make those general medical decisions. But we often tell clients there may be one or two decisions that you want to get out in front of now so that that medical agent knows what you want in the event that you are in a life-threatening situation. And I tell clients, let's say that you are unconscious and in a coma, right? You don't have to be in a coma. You have to be unable to communicate.
Correct.
And you're in a situation where things are not looking good and you are on some sort of life-sustaining treatment. And now a decision has to be made in consultation with doctors about whether to keep you on that artificial treatment or, as they might say, pull the plug.
Right. Pull the plug and allow me to die as gently as possible.
The advanced
Right.
directive to physicians is your ability to say, while you're healthy, how you would want your medical agent to behave or how you would want to be treated in that type of scenario.
Okay, so think of this. We'll go back and kind of list it out. So first one we talked about was was the durable power of attorney for finance. That's one document. Another one is medical power of attorney, who they can give decisions, who can make decisions on your behalf when you cannot. So, and then directive to physicians, which is kind of the pull the plug document, basically, in that regard. And I think there's really another one that I have seen sometimes missing. It's the HIPAA language. I've actually seen HIPAA missing. That was the Health Insurance Portability Accountability Act. It was actually passed in 1996. They started enforcing it in 2003. If you're ever going to look at something in regards to your directive to your medical power of attorney, there should be HIPAA in there. And it's big old bold letters, HIPAA. So tell them what that really does in regards to HIPAA, what that does for those specific medical directives.
Absolutely, and you hit the nail on the head. HIPAA is the acronym for the act that creates a federal privacy law protecting an individual's medical records from unauthorized access or disclosure. So the authorization that we always include with our medical power of attorney gives those named medical decision makers that you choose the simultaneous ability not only to consult with your doctors to make treatment decisions, but also to receive otherwise protected copies of your medical records. You want them to have those things so that they have the best information
Sure.
available in order to make decisions on your behalf.
So that's basically a HIPAA language that you want to make sure. Sometimes it's melded into the medical power that I've seen. Sometimes it's a separate document. Either way, we encourage people to have that. Another one is guardianship document. Now, many times we think of guardianship for children. They're minors, they can't make decisions for themselves, and so who's going to make those decisions? But what if you're an adult? So here's the general rule that I say. If you have an 18-year-old and they're in college for the first time and you're paying their college bills, think of it like this. You realize your children have to give you permission to get their grades? And so the reason that is because they're legally an adult. And so if they have to get permission, give permission for you to be able to get the grades of the classes that they are attending, imagine what happens in regards to medical decisions or power of attorney decisions. And so guardianship also is, once you hit age 18, it's basically if you can't speak for yourself and you are being placed in a nursing facility. So think about that. You're over age. You can't make a verbal and say, my wife is in charge of me, let her make the decisions. I can't verbally say that. So the guardianship document, tell them what the guardianship document does. How does that speak for them?
When we are planning for disability, there are steps along that process. Some steps we anticipate may happen, some things we hope may never happen, right? We anticipate that we may become disabled either temporarily or on a long-term basis. And so we sit down and we do the medical and the financial power of attorney documents, and we hope that that's all that we ever need. And if we go downhill, then we understand that we have life support planning documents in place that give some direction. But there are other situations where the disabilities that affect us may affect our mind but render our bodies perfectly capable. And I'll give you an example of how I describe this to clients. Your body may be perfectly capable of driving a car, but your mind may have you at some point driving the wrong way up the interstate. Your body may be perfectly capable of taking a walk, but your mind may have you taking walks at 3 a.m. in a bad part of town. And if you reach a point where because of that kind of incapacity, that you are no longer able to live independently, you're no longer able to keep custody of yourself, and you need someone to step in with court-approved authority to basically become your legal parent all over again, that what it's called is a declaration of guardian in the event of incapacity. So in the event that you become that kind of incapacitated, that document states in advance who you would want, and sometimes most importantly, who you would not want to take guardian, to be your legal guardian. We see this a lot with disputing adult children, where they can't agree on who should provide for mom's care, but maybe at a time when mom was okay, she did power of attorney documents supporting one child to be her decision maker, and that child has either stopped doing their job well, maybe they've taken some money from mom, there's a whole avenue of inside elder abuse out there, but now the other child who wants to step in and does the right thing lacks the ability to do so with mom's consent because mom's become incapacitated.
Right.
She can't do new documents. Going through a guardianship proceeding and having those advanced designations of who mom would want to serve in place helps a court understand who would be the proper legal guardian. But the idea is to think of incapacity as steps along a trail or stops maybe along a train route or whatever. Where back here, when we're doing power of attorney planning, these are less restrictive alternatives to the legal guardianship process, but sometimes we have to go the legal guardianship route because we're not left with any other choice.
So it's a lot of documents. It's basic documents, and this is not a Cadillac version. These are basic documents for you to be able to have your loved ones act for yourself financially, all the type of financial transactions that need to occur every day, paying bills, talking to companies, acting on your behalf, medical decisions, privacy decisions, guardianship decisions. And these things, honestly, what I have seen in my practice is I've seen families use those documents far more than they're going to ever use the dying side or the passing side, because you only use those once. In the living side, you're going to use those constantly. And I don't mean once or twice. I'm talking monthly when you get into incapacitation, Alzheimer's, dementia, any type of stroke issues where they cannot make mental decisions. Then all of a sudden, those documents become very, very important for families to be able to continue on with those daily activities.
There are some important statistics to bring up with respect to this kind of planning, and probably the most notable one would be that currently 7 out of every 10 adults over the age of 65 will experience some sort of long-term disability in their life or require some sort of long-term care. And so it's these documents that come to bear whenever we're dealing with our just the natural downward slope that our I'm struggling for the words right now.
Well,
our natural physical breakdown, I guess.
Right.
Is
Well,
what I'm
you
trying to
just
say.
nailed it. Over 65. I mean, when you're looking at 65, that makes a huge difference when you say 7 out of 10 of us. So if you got a room of 100 people sitting in a room, you're talking 70 people out of 100 are going to need some form of care either in their home, in an assisted living, in a nursing home, or in a hospital. And so it's pretty staggering. And so that's something where we're going to say, we want you to be proactive in your approach for your family and for yourself, not reactive. So hopefully this has been helpful. This is Strategic Estate Planning Services, the estate plan, basically part, what we call 101, but part 2 in regards to the living documents. Lorne, why don't you go ahead and tell them what's the best way to get a hold of you so if they've got questions on those documents, they can call you directly and contact you.
Absolutely. So you can check us out on the web at www.booklawfirm.com. So it's book like the one that you read. Or you can give us a call at 214-305-6974. We're in Carrollton and would love to serve or answer any questions that you may have.
Thank you guys for being here with us. We appreciate you being here for another Strategic Monies Tip. Have a great week. God bless you and stay safe out there.
Thank you so much for joining us for today's Strategic Money Tip. If you have any questions about the material covered in today's video, or you'd like to speak with someone from our team, simply call our office at 1-800-381-8870. Also, while we have your attention, click the link below to watch our latest video. And to see more videos on tips just like this one, make sure to click the logo to subscribe to our channel. On behalf of the team at Strategic Estate Planning Services, thanks again for watching.